Reuben, congratulations on your wonderful settlement with Abbott. And I want to ask you right off the bat, tell us about the settlement process and tell us what that was like and how it came out.
Well, it's been a long haul. I mean, the case began about 4.5 years ago, and actually it began 5 years ago. I'm sitting here at Emory Law School. It began 5 years ago when I met the client when I was here for the Emory Trial Techniques program. And so in some regards, I sort of look at this case as my Emory case in many respects. But it took us, I'd say, between May and the fall of 2007 to put the case together. We had thousands and thousands of documents. We had to, analyze and organize and try to make sense of in terms of the company's conduct, in terms of its marketing of the drug Depakote, in terms of...
Tell us about Depakote. What's Depakote like?
Depakote is a anti-epileptic, and it's got only 3 indications. It's got indication for migraines, mania associated with bipolarity, and absent seizures. These are very, very limited indications. The indications don't permit the drug to be used on children, that is anyone under the age of 18. And they're not indications that allow the drug to be used for patients who suffer from dementia in nursing homes. And unfortunately, this is a company that made a decision that it couldn't make enough money by marketing the drug for the lawfully indicated purposes. So it went out and marketed the drug off-label. And what we've seen with Depakote, what we've seen that Abbott has done here, unfortunately has been the pattern over the last several years for a number of drug companies like AstraZeneca and so forth with its drug Seroquel and Johnson & Johnson with its drug Risperdal. And so this is part of a pattern of practice that's going on with the drug industry. It's costing the Medicare and Medicaid system a ton of money. It's costing our state health and welfare funds a ton of money. And fortunately, we had the honor of representing a whistleblower who just one individual could bring this to the attention of the government through the laws that Congress passed and be able to seek redress that affords relief for many and our government.
So who is the whistleblower working for?
Well, the whistleblower was a longtime pharmaceutical rep, an honored rep, a celebrated rep for Abbott. She was, when I say a pharmaceutical rep, she went out, she talked to doctors about the drug, Depakote. She went to hospitals, she went to nursing homes, she worked with the community in getting the message out about Depakote. And essentially, after a while, what she began to realize was that the message this company was telling her to deliver was not really a message that was consistent with what the FDA, what was permissible in accordance with the Food, Drug, and Cosmetics Act and the regulations that were promulgated by the Food and Drug Administration.
So say more about that. What's the fraud here? What's the misrepresentation that's going on that potentially is causing harm in patients?
Well, the basic thing that goes on is that a drug company gets a drug and they get an approval for the drug by the Food and Drug Administration. And the FDA doesn't merely say, go use the drug for any purpose. They give it what's called an indication. And the indication is very limited as to disease, the specific manifestations of the disease, the dosing requirements, the age requirements, whether the drug can be used as an adjunct therapy or whether it's a combination therapy with other drugs.
So you mentioned that there was use of it potentially in elder homes with the elderly for controlling dementia.
Right.
So as I understand it, then there are different classifications of drugs. Some are antipsychotics or psychotic-related drugs, and some are really controlling epilepsy. What's the difference there, and what's the potential draw to use it in the antipsychotic?
Well, I would say this is the joy of being a litigator or a trial lawyer, that I didn't go to medical school and I'm not an expert in science, but through my work with the experts, I've been able to understand this, and it would have been an enjoyable experience. But basically, you have a category called psychopharmacological drugs, and you have certain drugs called anti-epileptics, which are, Depakote is one of them, and it's on the market to deal with epilepsy, but effectively it has a sedative effect. And then you have the antipsychotics, which are really designed to address, serious mania, and they're very different drugs. But they both have, at the end of the day, a sedative effect. And I'm sure if I had a doctor here, they would be able to articulate this in more scientific terms. When you have patients in a nursing home, what we have in our country is a problem where our nursing homes are understaffed. And you have a nursing home industry is predominantly a corporate industry that's motivated by profits. And what the industry wants to do is they want to deliver the services to the patient, the resident, at the lowest possible cost. And in order to do that, what they do is they cut the staff. And you've seen a lot of the large labor unions complain about this, and obviously there's been some community uprising and quality of care issues, but a lot of it has to do with the understaffing. And as a consequence, what I think is really happening is that patients are being put on these types of drugs to sedate them. And if you sedate them, then they're in bed, and as a consequence, you don't have to staff the home with the same level of staff. And in this particular case, you know, Abbott understood that a lot of the homes were using antipsychotics, and Abbott wanted to capture that market. And as part of their marketing strategy, they basically said, and it's alleged in our complaint, look, you know, if you use the antipsychotics, there may be some requirements under the Omnibus Budget Reconciliation Act, which is a congressional statute that requires you to do certain validations if you're going to use these psychopharmacological drugs. And our drug is different. It's not an antipsychotic. And when we took a look at this, what we were able to ascertain was, no, wait a second. Abbott telling these homes that they did not have to engage in the same level of diligence that they were engaging in with regard to the use of antipsychotics was just not a proper statement. So they were using a misrepresentation as to the reporting requirements or the obligations under OBRA in order, as a technique, as a catalyst to market their drug. And that allowed them to up the number of prescriptions, and as a consequence, the Medicare and Medicaid system had to pay out more money.
So now, when your whistleblower starts to feel like, I think I'm potentially misleading folks about the characteristics of these drugs, I'm marketing these drugs as potentially controlling people's behavior and controlling it, but I'm not sure that it's right for them. It might over-control them, or it might create some health risks to them. When she starts to learn about that, now how do you gather the evidence in order to be able to make your case to the U.S. attorneys, to present your case to get some attention on it?
Well, first of all, let me go back. I mean, whistleblowers don't wake up one day and say, I'm going to blow the whistle.
Right.
It's kind of like Elizabeth Kubler-Ross, the 4 stages of reconciling that you're going to die.
Right.
And the analogy I have is that people really who are happy in a workplace, people who are happy with life, don't want to find fault with the workplace. And the company gives them some solace with the idea that, you know, we have corporate compliance, we abide by government regulations, so you don't have to worry about it. So first, you know, the stage or the whistleblower sort of looks at it and says, you know, there's something wrong here. Then they say, well, it really couldn't be wrong because we have a strong compliance program, we have rules against it, we have lawyers, this is a big company, so it must be okay. And then the whistleblower does soul searching, engages in a series of questions, begins to ask the questions of others internally, and at that point comes to the conclusion, you know, I need to see a lawyer because I need the lawyer to either tell me that, you know, everything's okay and I can continue to work here, which would be just fine, or I need the lawyer to tell me what it is I need to do. And so when the whistleblower came to us in this particular case, we were at that final stage, and at that point, you know, we began the process of really just doing fact-finding, and as we do with any client, and, you know, ascertain what it is they know, what documents they have that can support their claims. We take a total look at the company's finances, and we say to ourselves, what would motivate the company to engage in this type of conduct? What type of representations have they made to the market? In other words, is it more likely? It's like, Paul, when we do these case files at Emory and we have a criminal case, you know, one of the things that you would look at to support the allegation that somebody stole from somebody or engaged in a robbery is that they needed the money. And so that's why it's critically important for us to look at the company's finances.
So you're looking for motive. You're trying to figure out, Is the profit side so tempting, so great that it might be coloring their judgment, or might they be in fact pushing too hard on their salespeople in order to get them to go ahead and market the drug and do it in a way that violates the statutes?
Right. You use the exact word. Motive is exactly what we're looking for. And we're also looking at the bonus structure. Are the sales reps bonused on on-label and off-label sales? In other words, if they cause the drug to be marketed illegally, will the company reimburse them for that? And that kind of subtle driver, facially neutral driver that drives unlawful conduct, those are the kinds of things that we're looking at. And we're looking at whether the CEO of the company is receiving bonuses, or his bonuses are reflective of just legal sales, or is it just everything? And so it's sort of the gestalt. That's what we're looking at, the entirety of the entire picture.
When you look at the medical piece of it, what fact investigation do you do to help you understand about the drug and about its potential harmful effects?
We absolutely cannot do a case like this without engaging a medical expert. We used a woman, Carolyn Poplin, in this case. Graduated from Yale Law School, went to the University of Rochester Medical School, was on the faculty of the Bethesda Naval Hospital. My co-counsel and colleague, Tracy Bushner, superstar lawyer, work with Dr. Poplin constantly. All the studies were analyzed. We looked at the marketing information that our client was handing out to the doctors, and often what you'd see is a marketing piece. You'd see a study that would potentially be used to market the drug off-label, right? And the study would, and this is typical a lot of the pharmaceutical industries. You see a study and it would say, don't distribute. But the sales rep would get 100 copies of it. So you'd say, well, if you're not supposed to distribute, why are you getting 100 copies of it? That makes no sense. And then sometimes what you see in these cases is the information is cherry-picked. The company's giving pieces of a study or a trial to the pharmaceutical rep. So it would require us to engage our medical experts to go back and analyze the entire study or entire trial results, and then come back to our client and sort of say, well, is this what were you told? Well, this is what the trial said. The study said this is what were you told, and so the scientific piece, the medical piece, is just critically important.
And Reuben, I imagine you started to get some pushback. That part of the pushback would be, well, isn't the individual doctor supposed to be responsible for finally making the decision as to what's prescribed and what's not prescribed? How did you manage through that issue when you were trying to figure out whether there was something that was really harming the patients?
Well, the industry has what I think they would call the atomization approach, which is, prove up every prescription, tell me that in this particular case it was the conduct of the drug company as opposed to the conduct of the doctor that caused the unlawful sale. It's a major issue in these cases because the law is quirky. It says that a company is not allowed to engage in off-label marketing on the one hand, but a doctor is free to use the drug for any purpose. So, you have a drug like Viagra, for example, which we see on television, and I don't have to talk about the indication for it, but, doctors may be writing that drug to address circulatory problems. In fact, they may use it for somebody who's 80 or 90, and they feel they have no other choice. The question is, when the doctor makes that decision, is he relying on studies or reports from the company that are accurate? So we look at the accuracy of it. In this case, the Abbott case, the allegations involve kickbacks or payments to doctors. We know as a matter of business judgment that a company is not going to take people to dinner or sponsor programs or pay any kind of remuneration or in kind or indirect without some kind of return on investment analysis. How much did we increase sales? They say, to the Dean of Emory Law School, we need to go to New York to raise money, and he says, okay, and then they say, well, how much money did you raise the last trip? There's got to be a return on investment analysis, and so those are the types of things we look at, and we make the overall argument that at the end of the day, that this type of conduct had an impact on the market, and I think it did.
When you and your colleagues were looking through these cases, do you remember an aha moment? Was there a time when you had somebody running into your office and saying, I can't believe this, look at this? Was there an aha moment that you recall when you were going through it?
Well, you know, I've been practicing law for 30 years, and I guess 20 years ago or 25 years ago, I had a lot of aha moments, and what I came to learn is not to aha so quickly because somebody's got the other side of it, right? So, you know, what you do is you methodically get the facts, and then you organize the facts that you think are important. You say to yourself, you know, I think that's going to be useful. That could be an aha.
Yeah.
And then,
well, let me
then you
try
wait for the
one
company to
on
respond.
you. I wonder, did you have going in already an idea of how much they were making on off-label uses on Depakote?
Well, we assumed that the number was in the high percentages, and it could be as high as 50 or 60%.
Of the total profits?
Of the total profits. And then the question was, how much of that was because of the company's unlawful conduct, and how much of that was because of the independent judgment of the doctors? And you get a sense of this, you know, based on the limited indications for the drug. And then what, at the end of the day, the government will be doing is they're looking at the diagnosis code for the patients who are getting it. And they'll see a patient who's has dementia, for example, and they call the ICD-9 codes, the patient who has dementia, and then they'll see an off-label use. So, you know, typically when we get a case like this and we see a very limited indication, but a high volume of sales, we're saying to ourselves, you know, something's wrong. And that's a mini aha, which says we need further investigation.
So I'm a doctor in a nursing home, and I have a choice between, as you say, a psychotic and an epilepsy-controlling medication. What would incentivize me to, if I could get the same control of the behavior, if I could even out a patient who might be a little bit frustrated or anxious as they're going through some kind of dementia, and I want to medicate that patient out, why would I pick one? I mean, the costs the same? Are the risks the same? Is the reimbursement process the same? What would, I guess, incentivize me to over-prescribe one of these medications?
Well, first of all, the nursing home market is very particular because you have a home, let's say, with 100, 200 beds, and you don't have a doctor for every patient. You may have, you know, a few medical doctors, medical professionals, who are making the decisions. And the thing that the industry does is they influence the consultant pharmacists, and they have the consultant pharmacists make the suggestion. Or they'll work with a consultant pharmacist to change the protocols to flow the prescription writing to a particular drug. Paul, the way I analogize this is if you go back to the, you know, civil rights movement, you know, the 1964 Civil Rights Act passed, and they said, well, you know, it's unlawful to discriminate based on race, gender, national origin. And employers said, okay, we're not going to hire you because of your race. And then they said, well, maybe there's some facially neutral things that will effectively cause cause us not to hire certain people. Like we won't advertise in a paper that has a predominantly African-American audience. And so what these companies do is they engage in facially neutral practices by changing protocols or working with consultant pharmacists to change the protocols that will have the effect of pushing a doctor or pushing utilization from one drug to another. One of the things they can do, for example, is they can pay kickbacks or create monetary incentives to have their drug on a formulary where the copay is less, for example, okay? Or they pay a kickback to a consultant pharmacist to push the drug heavily. That's less facially neutral, but the changing of the protocols is one of the things that you're looking for in these cases.
So you got a motive, you see that there is evidence that in fact there is a real steering going on toward Depakote where it shouldn't go on. You've got use of studies that you find inaccuracies as to what it is that's going on. You've got a pattern in practice in the marketing of the drug that prevents incentives to the individuals to go ahead and really push it. The incentives are so great and so high, people are making so much money that you're feeling like there's too much of a push. So you have this information, you're getting an idea that in fact there's overprescriptions of these drugs that could potentially be harming the patients that you described. So the next step is you write a complaint and you go to the Justice Department?
Okay, so the False Claims Act, if I can dovetail into this, is it's a really quirky, peculiar statute, and it goes back to the administration of Abraham Lincoln. You know, everybody thinks I think about history better than I do, but Eisenhower and the military-industrial complex. But we began to privatize really in the Civil War, and Congress passed this statute to as a means of redress to keep the private contractors honest, and it was reinvigorated in 1986. And if you remember the $12,000 hammers that everybody talked about during the Reagan administration.
Lincoln was concerned about horses, as I recall.
Lincoln was concerned about horses. The Union Army had private contractors tending to horses and mules, and they were worried that the contractors would keep some of the mules and keep some of the horses, and the Union Army wouldn't get the benefit of the mules and the horses. That's the story that everybody in my business talks about.
Yeah.
So the statute has some particular requirements, okay? And one of the requirements is that with a complaint you make a full disclosure of the evidence that supports your allegations.
And the fraud here, just to make the link here, right? Because between this and pharmaceutical companies, the link is with Medicare and Medicaid fraud, right? It's, in a sense, it's government. Though Medicare and Medicaid there's a way to look at it as not being government officially, it certainly is funded by government, and there are government programs that are involved here. So if there's fraud on Medicare and Medicaid, am I right?
Right.
Then there's fraud on the government, and that's what implicates the False Claims Act?
Right. It's Medicare, Medicaid, TRICARE, which is the military healthcare system. The Department of Labor has nursing homes for black and brown lung. There's a whole host of government programs. I want to sort of pick out one word you used, and you used the word fraud. And as we all know, fraud involves some element of reliance, that you make a false representation with the intent that I am going to rely on it to my detriment and I suffer damages, because there has to be a material somewhere in there. There is no reliance requirement in the False Claims Act.
Why is that significant? What difference does that make?
Well, because I don't have to show in a false claims case that a statement was made and that the government relied on that statement to its detriment. I only have to show in some circuits some element of materiality that had the government, if the government had known about this, they might have done something different. And so when we talk about the False Claims Act, everybody talks about it as a fraud statute. And when the government brings these cases, they often put in a parallel fraud count, civil fraud count. But technically it's not a fraud statute. The courts scrutinize a false claims allegation as if it were a fraud statute. They require you to plead with particularity under Rule 9b, same as fraud, but it's not a fraud case. In
a sense, part of then the policy behind that is that the government has a right to, before it disperses taxpayer dollars, it has a right to good information, and if it's being misrepresented, then they don't have to say, well, I was relying specifically on a statement. The government can say, if you're making a misrepresentation, I'm tasked with being a trustee of the tax dollars, and I need to make sure what you're telling me is correct. Is that part of it?
It's a terrific encapsulation of what this is about. There's an old Supreme Court case called Neifert, and really what it talks about is a wrongful course of conduct that causes the government to pay out monies. And that's really what you're looking for. And at the end of the day, when you're putting a case like this together, then you begin to, as you get into your factual analysis, the false statements, what representations were made to the government.
Well, but in a way, isn't it true that the government can be seen as almost a cash cow? Boy, if I can, they're so busy, they're looking in so many different directions. If I can put one over on the government, first of all, what's the harm? And number two, it's just part of doing business with the government that you try to get as much as you can out of it. And I guess I'm prompt and I'm trying to get your reaction to Holder's statement about how much fraud in the Medicare, Medicaid area in particular is going on in this country.
Get about up to $60 billion in Medicare and Medicaid fraud every year. You know, if you recall, back in 2011, when Congress was debating about whether to shut down the government, the amount in dispute was $30 billion. So we're talking about an extraordinarily material amount of money. And unfortunately, while the False Claims Act has been effective, at its peak, it's captured or been able to recapture about $3.5 billion a year and return that to the system. So what you've got is a situation where you've got a shortfall of up to $57 billion, and the companies know that in some cases it's worth the risk of breaking the law because they're only going to pay a small portion of what they've made back to the government.
Take us back. We have been kind of holding back on what your settlement is. Tell us about the settlement itself.
It's a settlement that will return $800 million to the federal government and the states. About $560 million will go to the federal Medicare, TRICARE system, federal government healthcare systems, and about $240 million will go to the states. You know, we're proud of that. We're proud of the fact that we've been able to return that money to the government, but we're more proud of the fact that in our settlement agreement, or you know, in our complaint at least, we've been able to put together a whole set of facts that we hope will be a catalyst for further investigation by Congress, the press, and hopefully, you know, this will be the tip of the iceberg in terms of, or the thing that sort of tilts it in terms of getting Congress during an election year to think about further regulation of the pharmaceutical industry.
And that was just on the civil side, right? You were talking about the civil penalties. Right. Were there criminal penalties in this case also? Right.
The civil agreement references criminal plea agreement, and you know, that is will bring the settlement, the total value of the return to the government to almost about $1.5 billion.
And so that's money that's presumably is back into the Medicare Medicaid system? Significant parts of it?
I don't know how the criminal part of it will be used. It may be set aside that damaged parties can petition against, but I can tell you that actually the $800 million will be returned to the federal treasury.
Reuben, how did you get involved in being a whistleblower lawyer?
Boy, well, you know, it goes back to when I was in college. Actually, worked for labor unions, and when I was here at law school at Emory, I used to, you know, take off and do organizing for labor unions and strategic campaigns for labor unions. I remember one time I left in the middle of the school year to go to Texas and then fly to Michigan or vice versa, and we were in contract negotiations with Beverly Enterprises, so I got to know the healthcare industry a bit. I was working for the Service Employees International Union, and I worked for a gentleman by the name of Ray Abernathy, who from Atlanta, and he had run Jimmy Carter's helped run Jimmy Carter's campaign for governor, and came from the Ralph Shune Agency, if anybody remembers that way back when. It was a terrific mentor at the time. He got me into labor unions. And when I graduated from law school, I was offered a job by Andy Stern, who was then the organizing director, the director of field services for the Service Employees International Union. And SEIU back then was about 800,000 members, and it was, you know, a union, an old line union of janitors, and had healthcare workers, and some jewelry workers, a small fraction. It had the people who collected the tickets at all the stadiums. But it wasn't really a political force. And you know, you fast forward 30 years later, John Sweeney, who was the president of SEIU, and I was there, ultimately became the president of the AFL-CIO. Andy Stern became the president of the Service Employees International Union. And I remember him in, you know, parachute pants and jeans and a T-shirt. And then I fast forward, he's on the cover of Newsweek, and he had split all the major unions, Teamsters, SEIU, United Food and Commercial Workers, away from the AFL-CIO, and one of sort of the big labor splits of the century. And these were sort of terrific labor leaders that I had an opportunity to work with. And And so, you know, the idea is that when I went to work for the labor unions, I looked at working for labor as a mechanism through collective action to drive change. I was always interested in public policy. And at SEIU, we were pushing for obviously better wages and working conditions and healthcare conditions. In 1990, we got involved in the bloodborne pathogens rule, and I worked on the OSHA regulation of bloodborne pathogens, and ultimately the universal precaution standard that's now used in all the nursing homes and hospitals, where you presume that any blood you know, is contaminated with HIV or HPV. And then I was involved in legislation at SEIU and testified twice before Congress on a bill called the Asbestos Hazard Emergency Response Act, which was an amendment to the Toxic Substance Control Act, and it required the inspection of all the public schools for asbestos. And I had actually written a report, I think in 1984, while I was still in law school, which was the basis for that. And I studied all of the, it's actually polled all the local education agencies throughout the country to see what they were doing about asbestos in schools. We issued that study through SEIU, and then we ultimately got Congress to pass legislation. So for me, working for a labor union was not only a way to help workers, but it was a way to drive public policy because you've got this collective force. But what
you and I have talked before about, you know, one of the things that you seem to be most proud of is that when you bring some of this litigation, sometimes it's not successful, but what it does is it generates a conversation out there in the news media and in the public that can bring about change, sometimes just as effective as if you got a victory in the court.
You know, you're bringing back terrific memories. The court, you know, Justice Brandeis, what did he say? That sunshine was the greatest disinfectant and the best disinfectant. So, you know, we have in this country a unique discovery process, and our court system is presumptively open. So, you know, my favorite example is that after I left SEIU, I went into private practice and I began to represent unions and workers. And one of my favorite clients of all time was the Old Oil, Chemical, and Atomic Workers Union, and that was, if you've seen the movie Silkwood, that was Karen Silkwood's union. And I was just immensely proud. And I'd work with this terrific labor leaders, Bob Wages and Tony Mazzocchi, who was actually the individual that Karen Silkwood was supposed to meet with before she got into her car accident. There's a lot of history to that. But the biggest thing I did, or most of my time, was spent with the nuclear weapons workers, and we were involved in the cleanup of the nuclear weapons plants because I think in 1991 the president had declared the end of the Cold War, and we ceased weapons production and we began the cleanup, and we were engaged in this question of, you know, do you use the incumbent workforce to do the cleanup, and or do you bring in new workers? And we were also interested in sort of the environmental legacy and the safety and health issues that pertain to the cleanup, and also how the radionuclides and the toxics that were used in these weapons productions affected the workforce. And so two great cases, actually, that came out of this that sort of speak to your point. One is a case called Okaw versus Richardson, emanating from the Oak Ridge plant in Tennessee. And the government had hired British Nuclear Fuel to dismantle the K-25 uranium enrichment facility, where they enriched uranium for the bombs that were dropped over Japan. And there are these huge cascades of compressors, and they compress the uranium hexafluoride through these what are known as nickel barriers. And there's immense value in all this nickel. And British Nuclear Fuel had this idea that they pitched to the government that they could recycle the nickel and put it into commerce. And, you know, we looked at that and we said, well, you know, you use nickel to make stainless steel, and what do you use stainless steel and use it for kids' braces, and you use it for soup spoons, and so we brought this case. And the argument that I made is that there was no environmental impact statement for this. And you know, the government moved immediately to dismiss, and that raised some factual questions. And I told the judge that there had been no factual record developed, and that although this was an administrative procedures case, I needed the discovery to develop the record so the court could ultimately make a ruling. And the issue before the court was whether this was something that was covered by, whether this is something that would require an environmental impact statement. And the government said no environmental impact statement was required because this was an environmental cleanup. And when you do a cleanup, you don't need an impact statement to do a cleanup, you just do the cleanup. And we said, well, you know, this recycling radioactive nickel and sending it out, that doesn't sound like a cleanup to me, that sounds like a money-making venture. And so we engaged in discovery to determine whether the sending this nickel out into commerce was actually part of the cleanup. And the government and British Nuclear Fuel argued that, well, if we don't do that, we'll have no place to put it. And we took about 4 or 5 months of discovery and numerous depositions, and we got this terrific opinion from Judge Kessler in Washington. And unfortunately, I don't have the opinion in front of me, but I remember it generally. And she said that the recycling of the nickel was, and sending it out was part of the cleanup. So she had to deny our request for an impact statement. And then she said, but this court wants to say some other things. And she said that this is an untested technology and this could expose, you know, people to harm. And she was extremely eloquent in how she communicated this message. And the next thing we knew, there was an ad by a public interest group, a quarter-page ad in the New York Times, quoting Judge Kessler. And you know you're driving public policy when you go to the cartoon section of the paper, and the Boondocks has your case, and they've got a kid with a radioactive spoon eating cereal. And we had delivered the message, and the Secretary of Energy canceled the contract. And you know, it would not have happened but for the discovery in that case. And we were really, you know, it's one of the greatest wins in my career coming out of a loss. And the other case I had was a radiation exposure case brought as a class action in Dayton, Ohio. And the court ultimately did not approve the class action settlement. But what came out of this was a lot of fact-finding and publicity that actually allowed us to work with the Department of Energy and drive Congress to pass nationwide compensation legislation that would presumptively compensate any worker who's got a disease, what we call a radiogenic cancer. And I remember vividly that, you know, the genesis for this legislation started, you know, after we filed the suit, and I got a phone call from Lisa Blatt, who, and as people grow, she's now one of the great, she was Assistant Solicitor of the United States. She was the Assistant General Counsel of the Department of Energy. She's now sort of one of the top Supreme Court litigators in the country. And she called me up and she said, you know, how about if we just do something for all the workers? And it was a terrific phone call, and it was a terrific result. And you know, I think about all the people across the country who have radiogenic diseases and are going to get insurance because of this program. So two great examples of where you win even if you don't really win on paper in the court.
So you're developing as a young lawyer from representing in collective way labor. You're taking cases that have to do with, it looks like, environmental impact issues, and you're also starting to move in more and more in these environmental hazards and the medical side of things. So that's where we are, and then still we're not quite to whistleblower yet. So how does that evolve further?
Well, you know, I realize that you know, workers themselves through collective action in a court can either drive union organizing or drive result without unions. And in 1990, I was involved in a lawsuit against Wix Corporation. Wix engaged in, at the time, what was perceived to be a hostile takeover of Owens Corning Fiberglass. And OCF had to restructure, took on a lot of debt, plants were closed, 1,400 workers lost their jobs. And you know, we brought a class action suit, and we got a settlement for the workers, and we were quite satisfied, and I hope they were. But I began to think about how litigation in and of itself could serve workers' interests, and then I got into wage and hour litigation, represented a lot of the meatpacking industry. And the False Claims Act was really quite intriguing. You know, many years ago I represented it, I first represented 1989, 1990, an industrial worker who complained that a contract for certain cases, the contract for certain products that were purchased by a foreign ally was covered by U.S. money, and the product that was being sold was defective. And I started to think about how this one person could have this one person with a 9th grade education, right, who put his information together in his attic on a Smith Corona typewriter, typing with 2 fingers, could have such an impact, where traditionally I'd thought that I needed a labor union or a thousand constituents. And that began to excite me.
And so you're maybe not the first whistleblower lawyer, but you're starting to get an idea that there are other ways to affect change by use of this false claim statute.
Right.
And when did you have your first whistleblower case? About what time did that happen?
I did cases prior, as early as the 90s, and I've been doing it for quite some time. The case that I'm initially most proud of, my first big false claims case, was U.S. XRL Johnson versus Shell, where I was part of a team of lawyers, and we represented 2 whistleblowers, John Martinek and Benji Johnson, and they worked for Arco Chemical. And what they understood was there was a scheme that the oil industry was employing by which they could shortchange the government on the amount of royalties that they had to pay on oil pumped from federal lands. There's 2,700 million acres of federal lands that are leased to the oil industry, and the oil that's pumped from that, the government's supposed to get revenue. And if you eyeball it, what we were seeing at the time was we were seeing a big difference between the NYMEX price for a barrel of oil and what the oil industry was actually reporting to the United States government. And Benji and John were able to articulate basically a series of agreements, what are called buy-sell agreements, between the various actors, 67 oil companies, whereby they'd trade oil with each other, and they'd report that as the price that they were getting to the United States government. So it was effectively, it was a conspiracy. The allegations were essentially a conspiracy to reduce the price reported, and it ended up in being the largest aggregate settlement at the time under the False Claims Act, which was $300 million, and now we're seeing settlements that mammoth that number. And what was fun about that case was, I came from a labor background, so now I'm talking about oil and gas and learning the oil and gas industry and understanding the protocol, and then taking depositions of the people in the oil and gas industry, and sitting in a deposition with the head of the Royalty Management Division of the Mineral Management Service in Denver, Colorado, with 60 lawyers from all the largest law firms in the country representing the oil industry, and objecting to the use of the word "the" and so forth. So over the years, through these bigger cases, representing small people, you get a quick education on how to practice law.
Now, this is just the start of a conversation I hope to have with you and carry forward, but if you type in whistleblower lawyer now, your website comes up, and it sounds like to me that you have captured, in a way, a high visibility of being a whistleblower lawyer. The problem, sounds like to me now, is to how to pick out from the cases that are coming to you which ones are good and which ones don't have the backing and don't have the evidence.
Well, you taught me this, Paul. I'm supposed to go back to Aristotle, and I'm supposed to boil it down to, what do we say, core facts? Core facts. And you want somebody who comes to you with core facts, not hyperbole, not legal conclusions. And then you want to match those facts to the law. And then you want to figure out who else is out there that can give you more information about that. You want to be careful about collecting the information legally. You don't want to infringe on any of the company's attorney-client privileges. You don't want to infringe on any trade secret privileges. You want to protect the interest of the company. And when you're doing public interest work, my experience is that you're going to be scrutinized heavily. So you have to be a zealot with regard to ethics and the practices, and that's one of the things that governs how we take our cases, who we represent, and the kinds of cases that we bring. We're very, very careful about that.
So let's return to Depakote. Is there anything more that we have not covered about that settlement that you think would be of real interest here?
I think when the press reads the settlement, I think the press the press needs to stop reporting on pharmaceutical settlements in terms of who won, who lost, how much money was paid. They really need to say, what is going on here? And you know, I'm opening my arms, Paul, because you've taught me this is, through trial techniques, this is what we're supposed to do, as opposed to this. But I've learned a lot from you. But and I'd like Congress to read the complaints, and I'd like somebody to say at the end of the day, you know what, enough is enough. It's not just that we can't afford to throw away $60 billion. It's that we're sanctioning or allowing companies to put drugs into people they don't need, and those drugs cause harm. We've got kids who have taken antipsychotics who now have diabetes. Our country is going to be paying money out for these victims for years, and that's the legacy of this unlawful conduct. And it's taxing our Medicaid system, it's taxing our Medicare system. It's making us, it's putting us in an uncompetitive position with regard to, you know, our foreign competitors. If you've got a company like General Motors and it's got huge healthcare costs, and the healthcare costs are attributable in part at least to drugs that should never have been prescribed, or illnesses or injuries that are caused by drugs that should never have been prescribed, this is something that Congress needs to look at. The other side of this is that the medical practitioners need to make medical decisions based on accurate information. You go to small communities in West Virginia and Kentucky and Ohio and Indiana, you know, these doctors unfortunately are relying on the pharmaceutical representatives who come in the door. And so Congress has to take the information distribution out of the hands of the company and into a forum, whether it's universities or whether it's a government entity. I know that there are people who don't like that idea, but the companies can control this flow of information. And finally, what I'd really like to see, and I'll make this pitch, is the Depakote case is a train wreck. When we saw AstraZeneca settle with regard to the drug Circle, that was a train wreck. Risperdal, it's a train wreck. We've seen verdicts with regard to Risperdal. These are train wrecks. And in our country, when we have train wrecks, we have National Transportation Safety Board investigations, so that those who are involved in the railroad or transportation industry learn from those lessons, not necessarily for the purposes of penalizing people, but from learning so we don't make the same mistakes. You know, Truman said, "What the only thing new is the history you've never learned." So I would like to see Congress promulgate something called the Pharmaceutical Safety and Investigation Board, and I would like to see that board have the power to look at cases like the Depakote case, and issue reports that explain what happened here, what mistakes were made, and to provide accurate guidance for medical practitioners. I also believe that a lot of information about these drugs is contained in the files of the Food and Drug Administration, and when a company engages in conduct like this, it should lose the right to have their information in those files, those FDA files, maintained in secrecy. Those should be an open book, particularly if the drug is on, you know, where the drug is on patent. There's no reason not to. So that's my wish list, and that's where I hope the Depakote case takes us. That's where I hope the next pharmaceutical case takes us. That's why I enjoy these cases so much.